Welcome to a JH Law video. Did you know that over $2.7 billion was spent by New Zealand businesses last year, and this all went to their research and development? These businesses were looking to expand into offshore markets, develop their digital capabilities, and even enhance local manufacturing, which is awesome for the New Zealand industry. And the reason I talk about how much was spent in R&D is because often we want to know, if we do buy shares, where is that capital that we're paying going towards? How is it helping companies grow? So, whether you are an existing shareholder or thinking about becoming one, here are JH Law's top 5 things to know about being a shareholder. Let's get into it. Number 1, tax. There are certainly several conversations you can have regarding tax and shares, but one that we can point out today is imputation credits. And what are these, you may ask? So these imputation credits represent income tax already paid by a company. That way, by the time the part of company profits that goes towards a shareholder as a dividend payout, that shareholder doesn't have to pay tax again. And there's some other bits and bobs. Number 2, dividends. A company can distribute dividends to its shareholders as often as it likes. However, there is always a duty on directors to make sure that the company will still be solvent after any distribution. And sometimes you will hear about companies having a dividend policy. Now, these guidelines are terrific documents that not only tell us how much money a company expects to retain and reinvest back into the company so it can grow, and how much it will give to to shareholders as dividends. But it's also a great document when you're capital raising, and it just shows investors that you really have thought about your asset allocations. And number 3, company decisions. How often shareholders might be called upon by directors to provide input into company decisions really comes down to how much control that shareholder has. So you may have heard of ordinary resolutions and special ones. Ordinary resolutions typically need shareholders holding at least 50% of the company's shareholdings in order to proceed with its contemplated transaction. And similarly, special resolutions are reserved for those major transactions where the company needs at least 75 of the shareholders to consent before going ahead. And sometimes it's quite helpful to look into your shareholders agreement, and there is usually a list of various transactions where shareholders will be required to give its input. Number 4, shareholder liabilities. How liable are shareholders? Unless it's been agreed otherwise, a shareholder's liability is limited to any amounts it owes on shares that it owns. However, do watch out when shareholders are asked for personal guarantees. Quite often banks will do their due diligence and look at how many shareholders there are in a company, and often ask that the bank receives a guarantee from all the shareholders, even if you are just a minority holder. If this does happen, it's often quite a good idea for the shareholder to try their best to limit that personal guarantee, or just negotiate for no guarantee at all. Number 5, the last one, and that's to do with privacy. So as you may know, details of shareholders are publicly available. This includes the shareholder's name and address. This of course has sparked much chatter in recent years for shareholder registers to be privatised. It's what we see in our counterparts in the UK and Singapore, where shareholder details are protected. But for New Zealand shareholders, we will just have to wait and see. Feel free to give this video a thumbs up or comment below. Of course, this video is just for informational purposes only.